Hi everyone, I'm here with my partner Anna. Say hi. And I thought it'd be cool. I've ordered this kit off of Amazon, Last Will and Testament DIY kit, and I thought it'd be funny to see if my partner Anna can fill it in. Yeah, they're designed for novices, and I'd say Anna's not quite a novice. They're not. No. Where am I going with this? They're designed to be completed by anyone. However, I'd say Anna's a little bit more experienced than most because she has me chewing her ear off about wheels all the time. So I think she might do okay on it. But yeah, it comes with an information guide and the wheel kit, which is just a fillable form. Thankfully, Anna's already got a will written by a really, really good estate planner. So we probably won't go ahead and sign this one. Because if she signs it, it will revoke any previous will that she's made. So we don't want that to happen. So,
who did my will?
A squirrel consult. Am I allowed to mention who you wrote?
Yeah.
So Anna's appointed her two sisters as executors so far. And then me as a reserve executor. So that means if her sisters pass away or can't or don't want to act, then I would step in. In this information guide, there's no details about inheritance tax. It does mention that if you have assets or property overseas, or if you own a business, or should you wish to set up a trust in the will, this isn't for you. However, my question to that is, how do you know whether you need a trust or not? This doesn't tell you. She's good. She's good. So there's quite a few extra lines. She's crossing out all the lines that she's not using, you know, like you do on a checkbook. So I'm not sure if anyone else would have done that. Obviously, where I've been on Anna's case and boring her to tears about
No,
wills.
I knew that before you.
Oh, did you?
Yeah.
All right. So we're now, after naming guardians, Anna's on to the specific gifts section. So that's if she was to give away her bike, for example.
My bike.
See, giving it away. So why do you have to put my bike? Anna, she's put my bike and my in capitals.
Because if I was to write a bike, that would have meant that my executors would have had to go out and buy a bike, not necessarily my bike.
Correct.
Whereas this states that it has to be my bike.
Exactly. So you must, when giving away specific gifts, put in the word "my" in front of your item that you're giving away. Because otherwise, yeah, I've seen people want to give their horse away, and if they put give away their horse, give away a horse called Hugo, then they just go and buy a horse called Hugo and give it to whoever they gift it to. But if they put my horse Hugo, she's giving her a microphone away. Anna's a really good singer. And she's given her a car. Not really it's worth much. Or gets driven much either.
Oh wow, there's loads. I thought it was just a thing.
There's quite a few lines for specific gifts if you want to give loads away. the bike to me, my microphone to my sister Vicky, my card to Sarah, my jewellery to Carol, which is her mum, and my house to mum.
No arguments. Right, that's it.
Okay. And crossing lines through all the other lines.
I don't have that many items as most people, clearly. It doesn't look very neat, does it? It looks like I've done this at school.
Well, that's probably more your handwriting. So residuary gifts, I give
Right. I've got to do this.
Well, no, I'm reading the thing out, what it says.
Okay.
So, is that all right?
Yeah.
Residuary gifts is next section that Anna's on to, and it says, I give the rest of my estate to my trustees to hold on trust to pay my debts, funeral and testamentary expenses, and pay the residue to the following. So, unfortunately, the first thing that gets paid when you pass away is your debts, any funeral bills, and any legal bills, or anything like that. And then pay the residue, which is whatever's left after those gifts and those other 3 items have been paid. It's the residue. I'll give you a few options there. So the next thing, Anna's decision that she needs to make is it going to be in equal shares absolutely, or in specified shares as follows? Should we cross that one?
In equal. You don't get anything.
Wow. So I've been cut out. So should any, and then it's got, so she chose 2 beneficiaries, her 2 sisters, and they're going to receive equal shares. And it says, should any of my residuary heirs not survive me, then I shall give their share of my residuary estate to... Dun, dun, dun. Oh, I've got a mention. On to the next section, funeral wishes, where Anna wishes to be cremated.
What would other be?
I don't know, you put in a rocket and sent to the moon. You can have a, could be cryogenically frozen.
No, I just want to be cremated. I don't have any special instructions. I'm not really fussed on that.
Just leave it there and then leave it up to Sarah and Vicky to argue it out.
Done.
Okay, let's go through this. So, first page, there's not really much that can go wrong. Full name, full address, it's fine. Then appointed Sarah and Vicky as executors. Hasn't put a full address for Sarah. I think that's more because she didn't know the address. But the problem is, if there is another Sarah, I don't actually mind, Sarah Drake, in the town that she is, then potentially we've got some stranger, Sarah, in this town being the executor, not her sister.
Nothing.
Well, there could be another Sarah in...
Yeah, no, but if it was my proper will, then I would have obviously done it. So I don't think you can mark me down.
Oh, yeah. Where's my red pen? Yeah, and then Victoria, and got the address there, that's fine. Then you've got replacement executors, you should put me, my address, which is fine. In a professional will, we would have probably put the relationship in there. So you'd have said, my sister Sarah of such and such address.
No, I didn't use my book.
And then replacement. Then appointment. The issue there, it's not a huge issue, but so she's appointed me, but she's put my name down, which is fine. That means that I'll be acting personally. Now, if she was appointed me as an estate planner, there'd be an additional clause there because I'd be acting in a professional capacity, and therefore I would have permission to charge. So as she's done it in a personal capacity, I wouldn't be allowed to charge. Then appointment of guardians, very clever here actually. That is true, you can put guardians down even though you don't have children, because it has got a clause underneath to be the guardian of any of my children who are minors at the date of my death. and should I be the sole surviving parent? So yeah, you can put guardians in, and it's very clever to put the lines underneath to cross out so no one else can come in and amend it. Yep. Then you've got, going back to my point as replacement executor, there's an amendment on there where she got my surname wrong. That could potentially be contested, and it could mean that she actually meant to appoint someone else as an executor. So we try to avoid amendments. Normally you have testator, Anna, and her 2 witnesses sign against that. You got appointment of guardians, that's fine. Replacement guardians, that's fine. On the appointment of guardians, she's put Sarah and Vicky. It hasn't specified whether they're to act Sarah, because Sarah's first on this list. So is Sarah going to be the main guardian and Vicky as a reserve, or are they going to be acting together? Because the problem is they live in 2 different addresses. So Anna's children are going to be split between 2 children, between 2 houses. Is that what she wanted, or did she want it to be Sarah as the main? What did you want?
I couldn't choose one. How? Yeah, no, I get that.
And then it's quite clear that Carol's then as a reserve. Specific gifts, my bike to Kieran. That's fine. Where's the bike to go if I died?
I don't know. Yeah. It doesn't ask you that, so I wouldn't.
Well, no, I'm asking you.
I don't know. I don't know.
Well,
Don't some people come to your house and collect everything?
so you don't care where it went. If I died, you don't care where your bike went.
Not the bike. I mean,
Okay.
like jewellery and
Okay, so
like the house. And yeah.
okay, so if any of these people died, so the jewelry in the house you put to Carol. So if Carol died, where would you want that money to go? That house and that jewelry to go?
Vicky and Sarah.
Okay, it would, and the reason being is that in the specific gifts, if those people died, it would fall then down to the residue, which then Vicky and Sarah are listed under the residue. So that's fine. Then you've got residue. So yeah, she's right. She's crossed out the plural and kept that's fine. And Vicky and Sarah are to inherit equally. So that's right, 50-50. That's what you wanted. What happens if Vicky or Sarah died? Where would you want their money to go to?
All of it to one of them.
So that wouldn't happen. So if Vicky died, she said she wanted Vicky's money to go to Sarah, and vice versa. That wouldn't happen. Based on the way that this has been filled in, if Vicky died, then Vicky's money would then be split under the next clause between me and the Bloomers Trust charity that she's put down. So you got that bit wrong. Would you not want it to go to their children?
Oh yeah. Can we?
So Anna's actually forgot her nieces and nephews in this.
I don't have nephews.
Her nieces in this. So
no, but when I say Vicky and Sarah, in my head I do mean the kids too.
yeah, well no, you don't know.
Yeah, I get that now and I see that. But I do in my head, just so you know.
Now it feels horrendous. So the way a professional would have wrote that is actually something called persterpes, which means that you would have said the gift 50% to, or equal shares to Vicky and Sarah persterpes, which means if any of them passed away, it would go down to the next generation and so forth. You've got funeral wishes, cremated, cheapest, that's fine. But again, hasn't crossed out other elements to it. So someone could also tick other and say she wanted, but they're not legally binding anyway. Funeral wishes. Last bit, Anna signed it, but there's no witnesses.
How was I meant to get 2 witnesses in the middle of the pandemic?
Good question you may ask. So, during the pandemic, there's a new law that's been announced which allows you to do video witnessing, which you can then go over Zoom or any other video conference site. We're not sponsored by Zoom. And Anna would then have a Zoom meeting with 2 witnesses. They would press record, and then Anna would sign, then put it in the post or drop it round to them, have another video meeting, the witnesses sign on Zoom, recorded, and those recordings will be kept on file. But effectively, this won't be a valid will because there are no witnesses. What?
Okay. I don't think that's something smart we do on.
Well, no, because it's not a legally binding will.
But I can't help that bit.
You can, so there's no point putting this in there.
No.
What do you mean? You so
No, forget that.
what do you mean? You should have spoke through it.
I'm genuinely serious now. What, so you're saying I should have forged that?
No, not at all.
Then how would...
Get the laptop out and have a Zoom meeting. I would say, 6 out of 10.
If I die, would this work?
No.
Pretty much, this is a basic will.
Yeah.
If I have simple requests. If I'm not too fussed about where my money goes after I die.
Yeah.
But
only if you fit it in correctly, though.
Okay.
As far as will packs go, I don't know if there's more comprehensive will packs, but there's quite a few bits missing, I think, as a duty of care to their clients. I think you should at least mention the benefits of seeing a professional, benefits of trusts, benefits of, or at least talk about inheritance tax. There's no mention here about inheritance tax, I don't think. No, there is no mention in here of inheritance tax. And the way that you direct your estate can affect sometimes your tax bill. So I think they should have at least mentioned tax in here. Equivalent of this from a professional is £200 roughly.
I think if you've got your own house and you've got important stuff and you've got kids involved or family, then I personally would want to pay a little bit extra. But before I was with you, I would have definitely picked one of these because I didn't realise how much could go wrong.
Yeah.
It sounds like I'm selling it now, doesn't it? I should be a salesperson.
Actually, one thing I didn't mention is you've cut me out, effectively.
Yeah.
So Anna and I have been together for a few years now. So she's actually excluding someone that might normally be a beneficiary. There is no mention in here as to the reason why she's excluded me. So we're not married.
Exactly. There's your answer.
So we're not married, but I would certainly have a pretty strong claim to, well, I wouldn't say strong. I'd have a claim on the estate and would be able to have a good crack at claiming on the estate. And there is no exclusion clauses in here as to why I've been excluded as a partner, long-term partner. Yeah.
Yeah.
So yeah. Thanks everyone. Any other?
No.
Thanks everyone for watching. Hope you found it interesting.
Like and subscribe.
Thanks.